25 CR 84 is now called the State of Texas versus Cody Deshaun Gale statute.
Yep.
Present with Mr. Paget, attorney and the state's attorney. Earlier, the defendant rendered a plea of guilty to this indictment alleging that he committed the third-degree felony of operating a motor vehicle while intoxicated with 2 or more prior convictions. Plus, the defendant pleaded through to paragraph 3 as well, which alleges that in 2002 he had a prior conviction for robbery out of the 331st District Court in County. So, how does this affect this? It's enhanced to a second-degree felony punishment, no less than 2 nor more than 20 years of confinement in prison, and a fine up to $10,000 is what you're looking at because of the third-degree felony by paragraphs 1 and 2 of the DWI because of the prior 2 or more DWI convictions, and then that robbery conviction, which enhances it 1 level. A pre-sentence report has been prepared. Have the parties had an opportunity to review it? Are there any corrections or changes to it? First of all, state.
None from the state.
And defense.
None from the defense, Your Honor.
All right. The court had some notes. I just want to, before we put this in the record here. In his page 2, the adult felony court history out of Travis County
Yes, sir.
of robbery here, just the second one, 5 years. It looks like he was sentenced to 5 years imprisonment. That was revoked
Correct, Your Honor.
on a probation, and then he ended up with 4 years in 2002. And is that the robbery we're talking about here that he pleaded true to?
That is my understanding, Your Honor. The charge was 99, and then the conviction was 2002.
Yeah, okay.
That's my understanding.
Yes.
Good question.
Then in another one here is the 2004 illegal possession of a controlled substance. It was 15 months state jail. And it looks like that was probated for 3 years.
Yes, Your Honor.
And then in 2006, then later in July of 2008, this states his probation was revoked. What happened on that? Did you just get 15 months?
Yes, Your Honor.
State jail?
What I see on my research shows that he did 15 months state jail on that case upon revocation. It was revoked on 7/29/2008.
That's correct, Your Honor.
Okay. So adding these up, is this correct that his felonies include that 99 robbery that is listed in the indictment? The 1 year state jail in 2002 for controlled substance. 18 months in state jail out of Travis County for, it looks like a crime that was disposed of at the same time that the other Travis County controlled substance crime in 2002 is disposed in September. Then he is revoked on that probation we talked about out of the 2004 offense that he placed on probation out of Travis County in 2006 and revoked in 2008. And then in 2008, when he is revoked, he is also revoked for driving while intoxicated with, he was sentenced to 12 months in the state jail at the same time as he was revoked on that probation for an offense committed. And I guess that's probably why he got revoked.
That's my understanding, Your Honor. In those sentences.
He was on probation in 06, and then in 08, he gets arrested and charged with driving while intoxicated with a child. So he has 1, 2, 3, 4, 5 prior felony convictions. Everybody add that up, right?
Yes, Your Honor.
His misdemeanors are much better. I'm looking at a 97 evading detention in Jefferson County conviction misdemeanor, a 98 Travis County illegal possession of marijuana misdemeanor, a 98 DWI out of Travis County, a 99 conviction for false statement for property or credit. I think I understand what that means. 15 days jail, possession of marijuana, and 24 days jail in marijuana in 99. So those are going to be all above Class C misdemeanors, I believe.
They are your.
So that's, so he's got 1, 2, 3, 4, 5 felony convictions, 1, 2, 3, 4, 5, 6. 6 misdemeanor convictions. That's 11 in courts of record. And then we've got this case to deal with. All right. Anything else to add on this pre-sentence report that we need to talk about or change? Otherwise, it's made a part of the record for the purposes of this hearing.
No other changes from the state.
No
Your Honor.
changes from the defense,
Okay,
Your Honor.
it's made a part of the record. Now, I've got another asterisk or two here on page 4. You probably sense what's happening.
You have the short
During the
version.
pre-sentence report, the defendant admits to a history of selling crack cocaine. So a substance abuse assessment was completed on October 5th. So that's last month.
Well, trials.
And it results in the defendant with a phencyclidine use disorder, PCP disorder, and severe alcohol use disorder, cocaine use disorder, and cannabis use disorder. Well, that hits the grand slam of disorders, 4 or more. Plus, the defendant tested positive for alcohol and cocaine during his assessment on October 5th. Did you know that? Did they tell you about that? So it's obvious that we got some problems here, and the abstinence of drugs is something that he is referencing. Based on the discovered findings, according to the probation office, it seems that neither jail nor probation is a deterrent. Therefore, prognosis for completing probation successfully was poor. I must say, this is one of the few times I read this because the probation office is a very positive group of folks. But what we've articulated here into the record is a very disturbing, consistent abuse of the rules and the laws. And then the question becomes, if jail or probation is not a deterrent, what are we left with? You can't be out there, out and about, operating a 4,000-pound missile when you're high on drugs and alcohol. And then something happens where you run into somebody, kill yourself or others, then it's who's to blame is the big headline. And it should be the person who's responsible. You know that your actions have consequences for all these times that you've been through the system. Then why haven't you gotten that? Why are you continuing to make the same mistakes? And we're talking about, how old are you right now? 47. Yeah, you had PCP in your early 20s. You had a PCP problem in your early 20s. So this is 20 some odd years of encyclidine. how you're not mentally deranged or deceased now with that consistency of misuse of such a dangerous chemical like phencyclidine is phenomenal. But just you're lucky to be alive. Others are too, who happen to be around you when you're operating a motor vehicle. But you're mixing drugs and alcohol and these are serious drugs. So the boundaries we're looking at are under the agreement, a cap of 8 years. So no less than 2 nor 8 years confinement in prison. That's an option. You got some other options in probation. So I'm gonna allow each of the parties a chance to be heard. State, you want to go first?
Yes, Your Honor. Given the report and all of the information regarding the defendant's substance abuse issues, continued use of substances, even on bond, in this case, we don't think that probation would be a good fit for this defendant, especially given the fact that he's been given the opportunity of probation before and it has not been successful. It's been revoked both times. Your Honor, we believe that the only deterrent to keep him off of drugs and alcohol is going to be confinement. And that's what we're asking for.
Mr. Paget.
Your Honor, I just want to point out a few mitigating factors. First of all, he has a history of severe drug and alcohol abuse, and most of his problems in life, after speaking to him, go back to the severe alcohol and drug abuse and addiction. I would like to point out that.
Can I ask just as we go, I'm going to dialogue.
And I ask him.
For any of this drug abuse is any of it a product of force use or was it free will by the defendant?
I can't answer that.
Did anybody ever put a gun to your head? You made choices. These were all your free choices up to now. Go ahead.
I just want to point out that he has voluntarily entered Unity House. So he's currently in an outpatient drug treatment program. How long was the program?
6 days.
And how far into the program are you now?
5 weeks.
Okay, so have you been doing the program? Okay, have they been testing you?
Test me yesterday.
Okay, were you clean?
Yes, sir.
Okay, so I'll point that out. I just wanted to also point out that other than the DWI, well, other than the current case, he has had no prior conviction since 2008.
Hold on. Let me take this up.
Absolutely.
Take it about it. How long have you been there?
In treatment,
Yes, sir.
5 weeks.
When did you go in?
Uh,
What was the date?
I think it's noted in the PSI. Let me see if I can.
I didn't see.
Oh, here it is.
It looks like October 13th.
Well, that was the date. I mean, I don't have verification of that, but he did state that the program started on October 13th of 2025.
Okay.
So that's what he tells me. I do not have the documentation to support that, but I assume it's accurate. And that's what he indicated to the PSI officer as well, Your Honor. So I do see some work here. I also would like to note that he really was a terrible work history, but over the past year, starting in 2024, he has been working. And his latest job was just a few months ago in 2025. So he's trying to make the change with the work history. Starting in 2024, he's had consistent work. He was 5 years fully employed. Where were you working? Okay, so he did have a job there. I also want to point out that it's been 14 years. And obviously, there's no excuse for all the cases before that. But other than this current case, he has no convictions since 2000, and I will say 8. So there has been the fact that he went for quite a while without anything. Also want to point out that he has a strong family support here, and he's more than willing to do whatever it takes to fight his addiction. Whether that be inpatient, outpatient, whatever the court requires. I seem to notice that there's been a big change in him as far as just his surrender in his admission that he actually has a disease and he does have addiction. Before, when I first met him, it was a lot of.
What's the disease? What's the disease?
Obviously, alcoholism and drug addiction.
Well, that's all self-induced.
I understand that
Okay.
completely.
All right. It's
He
not like he caught
took the first hit and he took the first drink, and it's been downhill ever since then. But At this point, I believe it's,
For how long?
It's more than a
From this,
choice.
from how, for how long?
speak up,
Sir,
For how long?
speak up. When you started using drugs, when you first thought that you were addicted.
well, I started using.
You started using marijuana at 13. How old are you now?
47.
That's, everyone's 34 years. Then powder cocaine at 22, that's 25 years. PCP, early 20s, 25 years. A quarter of a century. Now you're worried about it? Now you're concerned? It's just that you're about to be held accountable. That's the only difference. I mean,
Well, Your Honor, he's been held accountable.
based upon the, it says neither jail nor probation has been a deterrent, and the prognosis for completing probation is poor. Well, there's another option, and that's prison. That certainly keeps the vulnerable people who you endanger by your actions safe, at least for a while. But
Your Honor, he had
tried
been
it.
held accountable
Yeah,
several times, but
it's never been a lengthy period, and that's the. We know when he is in prison, these bad things aren't happening, and that only seems to be the time in 1, 2, 3, 4, 5 separate times that we get relief from your drug abuse is when you're in prison, and that's the only time. That's why the probation office was frustrated, and that, hey, we've tried, it doesn't. The help, you just are not cooperating with the helpers to make the right choice. So what are you asking for?
I think your only choice would be the state's offer or defer. It's my understanding. And that's what we're asking for with.
Your Honor, you briefly mentioned it, that the only time he has received is not a lot, given that and probation's prognosis of him not being successful on probation, and that the time in jail, in state jail that he's received so far have not been a deterrent. We are asking for the full 8.
Response, any response, James?
Your Honor, I would ask that he be placed on the maximum number of years deferred adjudication that he had complete control over with mandatory drug treatment. And in the alternative, Your Honor, I would be asking for less, or obviously under 8 years TDC if you were not inclined to waive this.
Okay. Mr. Nels, what about you? Anything you'd like to add?
Speak up.
Yeah,
This is your time to speak.
not done it, I was young, but not.
Sir,
No.
say it again.
I think I could change. I was young back then doing crazy things, but I was young now, more responsible. You know, I messed up. Great.
Well, I think he's trying to ask you what's changed, and she needs to hear you, so you need to speak up a lot louder. Like I'm talking. Everybody can hear you. Speak up. What's changed as far as your addiction goes? I can't say it for you. Speak up. Come on, let's go.
I'm enrolling myself now into treatment. I'm not use drugs or anything no more like that.
Well, okay.
I'm just trying to.
You've been making those promises for 25 years that you weren't going to do it again. That's after you were placed on probation in 2000.
Yeah, I was young then. I mean,
You were young then. What's the difference? That's 25 years later. You're still making the same foolish errors. You haven't changed for the better. We just tested you for alcohol and cocaine a month ago.
I think I changed though.
You changed since October? No, you've had 25 years of consistent abuse of drugs and misconduct. 25, a quarter of a century. You're still doing it. We didn't charge you with illegal possession of cocaine or alcohol, but we could have. It's just, this is, enough is enough. But you know, being in prison so many different times, over 10 times, you know it has consequences to it. Anything else?
Nothing further.
I'm going to find that the defendant has pleaded guilty in this cause number to paragraphs 1 and 2. And 3, true to 3, which carries with this the operating a motor vehicle in a public place while intoxicated, a 3rd-degree felony, enhanced though to 2nd-degree punishment based upon his prior robbery conviction that he is pleaded true to in 2002. Paragraphs 1 and 2 constitute the 3rd-degree felony since he has 2 or more prior DWI convictions in paragraph 2. And thus I find the defendant guilty beyond a reasonable doubt as State's Exhibit 1 admitted in his plea agreement plea hearing supports his guilty plea to find him guilty beyond a reasonable doubt of this 3rd-degree felony enhanced to a 2nd-degree felony. And the court does find that the enhancement paragraphs are true and correct beyond a reasonable doubt. So I hereby find the defendant guilty beyond a reasonable doubt, and I'm following this agreement. The defendant is sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 8 years. And you will be taken into custody immediately. I would urge you while in custody to take the benefit of any opportunities that the prison authorities have to help you in your inability to refrain from substances, which has been the root of your problems. But a quarter of a century of consistent misconduct in this is more than enough. You've had more than enough occasions to fix this. And I've got to say that under these circumstances, when you're looking at up to 20 years, your attorney was able to work in agreement with the state that is surprisingly low based upon your culpabilities because of your history. You were fortunate that you had him to at least minimize the damage that you have caused. All right, that's the findings of the court, and you were judged guilty and sentenced to 8 years in prison. You will be given credit for all time you have served by this case. All right, that is all. Thank you.
Madam, excuse
Yes,
me.
sir.
Thank you, sir.
Derek Leger or Derek Ledger.